The Supreme Court's ruling Monday in former President Donald Trump's 2020 election interference case makes it all but certain that the Republican will not face trial in Washington ahead of the anticipated November election. The Supreme Court did not dismiss, as Trump had wanted, the indictment alleging he illegally schemed to cling to power after he lost to President Joe Biden. But the ruling still amounts to a major victory for the presumptive Republican presidential nominee, whose legal strategy has focused on delaying the proceedings until after the election. Well, joining us live this morning to put all of this into perspective is columnist at the Washington Examiner, Quin Hillyer. Quin, good morning to you. Always a pleasure when I get to speak with you here on Live Now.
Thank you for having me on, Jeané.
Absolutely. So if you can put this into perspective first for the viewers, for those that aren't really familiar with what SCOTUS ruled.
Well, what they did is they said that there are some areas of his power where the president is, quote, absolutely immune from all prosecution. And that would be use of the military and diplomacy, things like that. But they named a whole lot of other things that were in dispute. Then they said he is presumptively immune, meaning that the prosecution, if they're trying to prosecute him, has a high hurdle to overcome to prove that he's not immune in any exercise of his official powers to the outer limits, unless the prosecution can show there is, quote, no damage to his use of executive authority. What that means in ordinary language is the president enjoys, according to the court, very, very large area where he is presumed not to be prosecutable at all in a federal criminal court.
Thank you so much for breaking that down, Quin. Now, we're looking at this as it relates to the former president, but this ruling will impact presidents to come. How will this impact them? And also, I want to ask you, we are looking at how this will impact the president, but some people wanting to know this morning, okay, if the president is potentially immune, it will have to fall on somebody at some point as for someone to be held liable.
Well, exactly. Let's take the first point. First of all, conservatives who are applauding this today are very short-sighted and in some cases hypocritical. I'm old enough to go back to the Bill Clinton administration, and if this ruling had come down during the Bill Clinton administration, probably 99.9% of conservatives would have been furious at this ruling. Likewise, if Hillary Clinton had beaten Trump in 16 and then Trump had won in 20, and this were applying to Hillary Clinton, again, the conservatives would not like this ruling. They would be outraged by this ruling, because what this does is it gives a very wide opening for a dishonest president to use his authority to go after the opponents and not be able to be criminally punishable. Now, yes, he could still be impeached and thrown out of office, but he would know that there's very little chance that he would actually have to serve any time in behind bars. And that takes away some very important constraints on presidential power.
And the second part of that question, Quin, as we look ahead, that, if a president is found immune of something that happens during his or her time in office, we look at who will this fall on, who will be found liable for that decision, and people looking at, okay, maybe the attorney that's on staff or even other legislators that are on staff.
Well, it depends on if they actually go forward with it. What this really means in practice is that there are some things that would just not be punishable at all. Now, because then the person that carried out the order, unless it was just patently, obviously criminal, such as direct murder, they would enjoy some sort of immunity, because they would say they absolutely had to follow the orders of their commander-in-chief. If, say, for instance, he ordered the military to do something within our borders that somebody in the military thought but wasn't sure was not correct, the assumption by the military member is that he has to follow the orders of his commander-in-chief. And so you get into a very gray area. And again, this has opened up a whole other can of worms.
Quin Hillyer, always a pleasure speaking with you here on Live Now from Fox. We appreciate your candidness and your expertise on these political topics. Is there anything else you'd like to add? Anything myself and the viewers need to be keeping a close eye on?
Well, I would just say that the person that got this right on the court was Justice Barrett, who was in the middle, Amy Coney Barrett, who said that, quote, properly conceive the president's constitutional protection for prosecution is or should be narrow. Nobody argues that he doesn't have some sort of immunity. The question is, did the court go too far here? I and a whole lot of other people think that it did.
Quin, thank you so much again for joining us here on Live Now from Fox. You enjoy the rest of your day.
Thank you. Thank you.
Absolutely.